Hello everyone, and thank you for joining my PyOhio talk. My name is Zelikman, and I've been developing software professionally for over 15 years. My experience spans all the way across meteorological applications, healthcare, and finance, and I've also had the opportunity to touch several very different technology stacks. For the next 10 minutes or so, we will talk about the case of Google versus Oracle and its potential impacts. I believe that if you are in the software world, in any position, you will find this talk informative and applicable to you. Disclaimer, I am not a lawyer. You might have expected this slide. And as I mentioned, I'm not a lawyer, and this is by no means a legal advice. Opinions here are my own. Let's start with a little bit of background. Sun released Java language in 1995. In essence, anyone could write Java programs. However, commercial derivative works, same sold for profit, of Java itself were licensed by Sun. In April 2009, Oracle announced it would purchase Sun, and as part of that, it had acquired all the intellectual property associated with Java. On the other side of the story, in 2003, a company called Android was founded with the goal of creating a new platform for mobile phones. In 2005, Google acquired Android and continued developing the operating system. Google was interested in incorporating Java Standard Edition libraries into the Android OS and was in negotiation with Sun to license Java Standard Edition. But those negotiations did not work out. Google decided to develop a clean room version of the Java version it required, writing it completely from scratch, relying to some degree on Apache Harmony, which was an open source Java implementation by the Apache Software Foundation. Google implemented 37 APIs and used approximately 11,500 lines of code deemed central to Java taken from Apache Harmony. By 2013, Google replaced all uses of Java code with its own implementation, however, continued maintaining those 37 APIs. Why is this case so important? This case was expected to be one of the most influential cases on the software world. Many assumed that if the Supreme Court will fully support the Oracle claims, then the impact on the software world will be disastrous. The software world assumed for years that re-implementing open standards is open for all and that has been a great vehicle for innovation and support of standards. At the same time, there are also claims that the ruling in Google's favor would reduce the copyright protection on software and would actually enable big companies to easily redevelop products created by small firms without giving these small companies a way to protect their intellectual property fully. This litigation lasted from 2010 until 2021. Over these 11 years, we had two case court decisions go in Google favor versus two appeals that sided with Oracle, leading to a Supreme Court decision made in early of 2021. At the first trial and appeal, Oracle sued Google over copyright infringement, asserting that Google developed Android without proper Java license and copied its APIs. The first trial revolved around copying a small function, test files, and also structure, sequence, and organization of APIs and their documentation. The jury found that Google violated Oracle's copyright when it came to APIs and other materials, however, couldn't decide if it was fair use. The main part of the verdict in the first trial was that while the jury found Google violated API copyright, the judge concluded APIs were not copyrightable. Following the outcome of the trial, both parties appealed. The appeals court found that the overall structure of Oracle's API package is creative, original, and resembles taxonomy, which led the appeals court to decide that the decision by the judge in the first case was wrong and APIs are copyrightable. It was sent to second trial to decide if the use by Google was fair use. Let us take a minute to understand fair use. The law in the United States strives to promote innovation, and for that goal, it protects the intellectual property of individuals or organizations. However, the law also allows, in certain cases, unlicensed use of copyright-protected work. The law recognizes that in some cases, it is unlicensed use that promotes innovation. Usually, the court will consider 4 factors to decide fair use. Purpose of use, for example, educational or nonprofit in general, will be more likely to consider fair use. Second factor, nature of the work. This factor looks at the nature of the copyrightable work, while using creative work such as a movie or a song is less likely to be considered fair use than a white paper. Third, amount of work used. How much of the copyright material was used and if the bare minimum was used. And the fourth one, effect of the use on potential market. The court will consider if the use harms the market and or the organization that created the original material in the market. The court might consider other factors, but usually these are the main factors. The second trial focused on the question of fair use. The jury decided that Google API implementation was protected by fair use. The appeals court decided differently, that Google's implementation did not meet the 4 criteria for fair use, but it was just an untransformed reuse. It was noted that Java has already been used on smartphones before, adding to the argument it has not been transformative and perhaps even hurt Sun or Oracle in their business. Google appealed to the Supreme Court, challenging the appeal court decision on 2 points. First, are APIs copyrightable? And second, was Google usage of them fair use as decided in the second trial? Many briefs from the industry were filed expressing concern if the decision would be supporting Oracle's case. Some briefs, including from the Solicitor General of the United States, sided with Oracle though. The hearing was postponed due to COVID pandemic and was heard in October 2020. It is an interesting discussion, and you can easily find a recording of it online. Listening to the discussion, there was a sense that the justices agree about the copyright issue Oracle presented. However, they also focused questions regarding the point made in a lot of the briefs presented by leading industry players, saying the industry would suffer significantly if Oracle should win. So it's really a balancing act between the interests of those 2 sides. The decision was 6-2 in favor of Google. In the majority opinion written by Justice Breyer, it was assumed, but not fully decided, that APIs are indeed copyrightable, and it mainly focused on deciding if the work done by Google falls under fair use under these 4 points. First, the nature of APIs is declarative, hence fair use is applicable. Second, Google extended the use of these APIs to a new operating system. Google only copied and used the minimum APIs it needed for this purpose. And the last one, at the time, it was not clear Android would be successful, nor would create competition to Java itself. Breyer agreed with the idea that finding for Oracle would risk harm to the public, and Oracle alone would hold the key. While happy with the result, some of the industry were disappointed the question whether APIs are copyrightable was not settled, hence not giving a clear direction on that question. In my opinion, this still allows our industry to continue moving under the previous assumptions that re-implementing some basic standard is permissible. The court settled the argument that if you re-implement the bare minimum of an API that you need for transformative work, that would be considered fair use. This allows the industry to continue producing innovative technology. This outcome protects organizations using platforms the way Google did with Java, as long as they are meeting the test for fair use. With that, I wanted to thank you for listening to my talk and thank the PyOhio organizers and everyone that have a hand in putting this conference together. If you have any questions, please feel free to reach out to me. I'll be happy to discuss the topic.